Yes, ma'am. I think all the settings are okay. Maybe we'll just join in a while before call.
तो लगी है इसके वीडियो
Over sir. Over.
तू आहे ना आणि पॉइंटर ज्यावेळेस कनेक्ट होशील ना पॉइंटरची
आता आपल्याला काय करायचं सिरीज स्टॉप करायचे आणि वेटिंग रूम प्रेझेंट करायचं रेकॉर्ड स्टार्ट करायचं
रेकॉर्डिंग तेव्हापासून स्टार्ट करायची
तिथं पण रेकॉर्ड करणार
पाच मिनिटे आधी होऊ दे रेकॉर्डिंग तर फरक नाही पडत फक्त नंबर ऑफ पार्टिसिपेट वाढलं ना की हे होणार
11:55
डेटा आहे पण नेटवर्क नाही भेटत काय अट्रॅक्ट काय ही मग पहिलीच चालू आहे पहिली
सबस्क्राईब केलं
हाँ गिलास नहीं रखा मैंने Got it.
ओपन नव्हतं केलं.
सुरू झाली meeting?
3 आहेत ते हे. ते तिन्हीच्या तिन्ही ओपन
मला काहीच येत नाही ऐकायला पण.
ब्ल्यूच आहेत त्याच्यामध्ये. ग्रीन नाही. कोण आहे 5?
मला युट्यूब नाही दिसत आहे. मला नुसतं एक पोस्टर दिसतंय.
ओके ओके चालेल.
12ची आहे ना मीटिंग. मग अजून 12 कुठे झाली?
सोमया
असं म्यूट करू. कसं करू म्यूट?
मला थोडासा आयडिया आहे ना तुम्ही जे फुलवाला बोलत आहे तसंच तो
वेबिनारचं आहे आणि शॉर्ट वेबिनार आहे 1:15 संपणार आहे त्यामुळे पाहिजे तर जॉईन होऊन
कोणत्या कशाबद्दल
ते
आहे?
शुभांगीने पाठवलं पेटंट फायलिंगचं आहे.
अच्छा
Hello. Hello.
Good afternoon, all. It gives me a great pleasure to have you all this first library webinar after the pandemic and as a part of the Azadi Ka Amrit Mahotsav to commemorate the 75 years of independence. On behalf of TMC ACTRA, we welcome you all to this webinar on patent filing procedures in Indian context for the Clinicians and Scientific fraternity. The ACTRA library has organized various events earlier on scholarly communication, academic integrity in research, research metrics, and make the space successfully. This is one more attempt to empower our scientific community and the clinicians in understanding the types of intellectual properties, what is patentable, and patent filing procedures and their importance of patent contributions in the development of nation. It has been observed research and academic institutes across the country focus on publishing their research in peer-reviewed and international high-impact journals. But filing for the patents for the discoveries and the innovations with the government protection is far low compared to the scientific publications. Today we have with us the speaker, Dr. Indra Dwivedi, a senior scientist from CSIR, who is going to enlighten us on the procedures and share her expertise on patents and filing patents in the Indian scenario. I take this opportunity to thank our director, Dr. Sudeep Gupta, for giving us the concurrence and support in organizing this webinar on patent filing. We are also thankful to our deputy directors, Dr. Prasanna and Dr. Naveen Khatri, for their support and encouragement to organize this event. And also, a special thanks to Mr. Kamlinde and the entire IT team, administration, and the housekeeping staff, logistic support in organizing this event. Brief introduction. Now, I request our Deputy Director, Dr. Prasanna, to address the audience on the importance of patents in basic research and their applications in the industry. Over to Dr. Prasanna.
Good morning, everyone. Can you hear me, Satish? You can
Yes.
hear me? Okay.
Yes.
And it's my pleasure to welcome our chief guest, Dr. Indra Dwivedi, who has kindly consented to give a much needed and important talk and share the ideas with us. And she has been formerly a chief scientist and group leader of Patent Innovation Protection Unit in CSIR. So I don't know if we could have found anybody else to educate us on this topic. Thank you very much, Dr. Indira. I will keep my talk very brief. I just was curious to know when people would have started this idea of patenting. Most scientists are driven by curiosity to do research, and the path to the research, the outcome of the research in terms of the hypothesis being tested and giving good results, or even if a product is produced, that seems to give immense satisfaction. And if it gets published in a peer-reviewed journal, it makes it even more satisfying. Beyond that, most of us don't go into looking to patent our ideas or products. Ideas, maybe you can forget, but at least the products, if they are in the pipeline. It was interesting that some of the first patents have been issued in 500 BCE, that is before Christ era. And what is interesting is that it is was given to creators of unique culinary dishes, that is for food and making them interesting. It's really nice to see that it had started somewhere there. And for all our mothers and grandmothers who cook excellent dishes with which you can't probably reproduce even when they give you the recipe, this is something to note. And in the biotechnology era, people consider farmers as being the innovators because they used to breed plants to get new varieties. And more familiar patents are the one by Louis Pasteur in 1873, when he patented an improved yeast making method at the French Patent Office. What is interesting to note is also before he made this patent, improved yeast patenting, there was someone in 1787 who was granted a patent for a yeast-like composition to be used for baking that was prepared from mashed potatoes. So Pasteur's is actually an improved one, and then he got a patent in his French Patent Office. This kind of gives an idea of what is the process of creative ideas, originality, and how you protect them. And most of us somehow think that this protection of the idea or trying to use it for commercial purposes is probably not the scientist's way of thinking, but things have changed a lot. And India needs patent. India needs patent in the biotechnology field, because that's the only way that we can compete with the rest of the world, and we need to do it for the country. And it is important that some of us who look at this in this direction, and we have a couple of scientists in ACTRIC who have successfully filed the patent and even licensed it in some cases. So I like to draw attention to two important things. For some of us who think that this patent is actually secrecy or protection, it really is not so, because while filing a patent, you're expected to give the full procedure in such exquisite detail that somebody else should be able to reproduce. You are protected for the time of patent, maybe 10 or 20 years, where any commercial benefit comes to you, but the product or the procedure itself has to be reproduced or given in, documented in such details that somebody is able to reproduce it. Number two, the patent being filed should have some utility, without which there is no value for the patent. So I like this idea that it is necessary to share these protocols in detail, so that anybody else who wants to improve on that has a chance to do it. And that's a nice way of looking at it. And I think without patenting in biotechnology, the compounds would be, or compounds of the procedure would be considered as something that is in the line of secrets. So that itself should be a good incentive for people, some of the scientists who think that patenting is not the bread and butter of the scientists. So with this, I think I'll stop and I hand over to Satish. I welcome once again Dr. Indra to this meeting, and I hope all the scientists, faculty, and the students enjoy this talk. And thank you, Dr. Satish, for organizing this. Thank you very much. Enjoy the meeting.
Thank you, Dr. Prasanna, for your thoughtful insights and just giving us historical perspectives of the patents in the biological sciences and the science discipline in particular. Now, may I request our director, Dr. Sudip Gupta, to say a few words on this occasion. Over to Dr. Sudip, sir.
So good afternoon, my colleagues and dear friends. Dr. Monoli, can you hear me?
Yes, sir. Yeah, we are.
So my apologies, I am unable to switch on my video. I'm outside of Mumbai in a location that has relatively poor connectivity.
You're audible, sir.
But I can hear you very well. So good afternoon. It is very timely that this webinar has been arranged by such an eminent speaker who is a domain expert and a deep expert in this field. And I'm sure this topic will be of interest to scientists and at least some of the clinicians. I just want to make two remarks. I was listening to my colleague, Dr. Prasanna. So she talked about Louis Pasteur and others. So there's a very famous incident, which maybe Dr. Dwivedi will also allude to. Jonas Salk, when he discovered the polio vaccine, he was asked why he did not patent it. And he said, could you patent the sun? And on another occasion, more recently, a sequence of DNA, a gene called BRCA, BRCA. And because of that patent, there were millions of people or millions of patients who could not access that test. And then the US Supreme Court sometime in 2012, I think, or 2011 ruled that a sequence of nucleotides, DNA, RNA, and everything that's made by nature is not patentable. So despite the fact that we are today talking about patents, there are some things that we must also understand which are not patentable, and it may not be ethical to patent them or try to patent them as well. My last point, so it is all right to say that scientists are, gazing into the blue sky and trying to do research because of ideas that come to them. But from a utilitarian perspective, it is a fact of life today that unless something is commodified and unless you can package it into a product that can be sold, the fruits of that research will not actually reach the intended beneficiaries. So you can make a discovery, but if you do not patent it, then there is a high likelihood that with no commercial interest on the part of any entity in that particular innovation or discovery, it may not actually reach a stage where it could be sold as a product to the intended beneficiaries. So whether we like it or not, it is a good idea to try to grapple with the complexities of patenting and intellectual property creation. And it does bring value in the end to everybody, including the society. Dr. Dwivedi, thank you very much. You have spared your time. I've heard a lot about you. I've never had the good fortune to meet you in person. Hopefully on some occasion, we will do that as well. And for today, thank you very much for joining us. I would also like to congratulate Dr. Munoli. Dr. Munoli, it is very it is your efforts and with that of Dr. Kishore Amin, and I think both of you deserve my deep appreciation for organizing this webinar. Hopefully this will not be the first. Maybe we'll do a workshop, maybe we'll have other engagements with Dr. Dwivedi and anyone else that she recommends, and we will take this forward. Thank you very much.
Thank you very much, sir, for enlightening us on the values of the intellectual property rights and their importance and their real applications in the industry. Now I request Dr. Amin, Kishore Amin, to introduce the speaker to the audience. Over to Dr. Kishore.
Thank you, Dr. Munoli, and thank you, Dr. Sudhir Gupta, as well as Dr. Prasanna, our director and deputy director. So, good afternoon, everybody. So, it gives me great pleasure in introducing today's vibrant speaker, Dr. Indra Dwivedi, who is known to me since many years, and we both have been serving in the Scientific Review Committee of the Department of Science and Technology, Government of India, sponsored program IRIS. So that is to do with Initiative for Research and Innovation in STEM for undergraduate students, also supported earlier by Intel and now by Broadcom. Her knowledge of patent filing has helped a lot of students and scholars in handholding them in patent filing, spreading awareness and its benefit thereof. Dr. Indira Dwivedi, formerly a Chief Scientist Group Leader of the Patent Innovation Protection Unit, CSIR, New Delhi. She has over 25 years of experience in different capacities in handling technical and administrative roles of patent filing in India and abroad of CSIR laboratories. She has experience in handling and drafting about 2,000 new patent applications in India and other countries. She drafted and filed patent applications in chemical sciences, particularly drugs and pharmaceuticals. Dr. Indira Dwivedi is well versed with patent application that includes prior art search, analysis of prior art to establish the invention and novelty and innovative step, and also evaluation of the patent proposals, especially meeting the enabling disclosure requirements. She played a responsible role at IPU in the administration, like monitoring various deadlines pertaining to filing of new patent applications, legal scrutiny of document before filing, either in India or abroad, filing the complete after provisional patent application, convention patent application, patent cooperation treaty applications. She is a very well qualified and registered patent agent, and also qualified the course at US Patent Law and Practice, George Washington University, USA. She is a registered patent facilitator for startup companies under the scheme for facilitating startups intellectual property launched by the Government of India on IPO website. Her strength is handling and filing PCT applications individually without attorney's intervention, handling opposition, hearing of IPO, intellectual property, appellate board, and other related matters. In her academics, she worked in the field of carcinogenesis of steroid endogenous hormones, particularly in breast and uterine cancers, as a visiting scientist of Epilepsy Cancer Research Institute, USA. These pioneering studies were published in Proceedings of National Academy of Science and Chemical Research in Toxicology. She officially visited several countries like France, Germany, Japan, and Sri Lanka to attend meetings and represent India. She also has over 30 publications and review papers to her credit in national and international journals, and also filed 2 patents for herself. So with this brief introduction, of course, there's a lot more, as our director has already mentioned, that we may be having her for some workshops and things like that. So with this, I invite Dr. Indra Dwivedi to give her deliberations. Thank you very much.
Thank you, Dr. Amin, for the kind introduction. I am also very much thankful to Dr. Sudeep Gupta, Director of the Institute, Dr. Amin, Dr. Satish, and Dr. Sinha for organizing this webinar and selecting me as a resource person for this webinar and delivering talk on IP. I'm really feeling honored, and while I'm delivering talk among such a esteemed audience here, the doctors, particularly in the field of cancer, the best doctors and researchers are there in this field. This subject is very, very important, as you can also make out, because the presence of a director in this kind of webinar itself indicates the importance of this subject. I think I should directly go to the presentation. I just want to say that India has been very much innovative since its beginning, and innovative activities are flowing from even rural areas to the cities. But they are not protected. They remain unprotected. The reason behind is they don't have knowledge or lack of knowledge on IP, how to do it. Funds are not there, or they think it is not required, or it is a cumbersome process. The patent filing or protection of any IP is a cumbersome process. So this is because of the lack of knowledge. But the Indian government is very much concerned about IP protection. So they have formulated the policy. National IPR policy has been framed recently in 2016, just to create facilitate the process of production. And lots of steps are being taken by the government to create the IP culture in the country. Even from the school level, this IP as a subject has been introduced at a school level itself. In colleges and all medical colleges, I don't know about the medical college, but engineering college, they are introducing it, because in IP policy, if you see, this is a subject now. So because they want children to start from the very beginning now. So this is the importance of IP actually. And I'm sure while I will be presenting my presentation here, I will try to give in a very elaborate manner. But if you have any further question which I am not covering, please let me know. And I'm very much honored while presenting among the doctors and researchers at the premier institution of Tata Memorial Center. And I'm sure I will be learning from your questions and interaction during the session. So I think let me start my presentation. I'm sharing my slides. Yes, I will be covering during this period, this session, what is IP system in India and abroad and its importance, what kind of intellectual properties are there, and more focus on patent system in India and abroad. Because each IP is a broad thing. I cannot cover in a single presentation here. So I will be more focusing on patents only. Patentability requirements, novelty, non-obviousness, and utility. As Dr. Prasanna already summarized the crux of the patent system already, a little bit about the novelty and inventive step, and prior art searches, I will be little bit talking about, and why public disclosures are prohibited before filing the patent application. This I would like to elaborate here. And what is patentable and what is not patentable subject matter under the Indian as well as in other countries. So, because the patent law does not disclose what is patentable, they elaborated what is not patentable, and then you have to find out how to make it patentable. So everything is all kinds of technologies in all fields are patentable, except few which are not patentable. I will be talking about that. And then in between, I will be having some case studies in respect of patentability requirements, process of filing, and cost involved. So it may be of useful for the audience today. So let me start with the IP. What is intellectual property? It is a creation of mind. Creation of mind may be invention, literary or artistic work, symbols, names, images used in the commerce. Any kind of this intellectual creations may be called as, may refer to the intellectual property. So it may be, there are two kinds of properties, intellectual property, industrial property and copyrights. Industrial property includes patents, trademark, design, plant varieties, and geographical indications. And copyrights, as you know already, literary work, if you write a poem or any film or music or artistic work, it is protectable under the Copyright Act. The performance rights of the actors and all films, they are protected under the Copyright Act. So let me start. We cannot avoid this IP nowadays, because you see, if we start in the morning, we start with the toothpaste as soon as we get up from the bed, and it is protected. You start from the morning to evening or the late night when you are going to sleep, you are using, everything is protected. Having tea, Darjeeling tea, Taj Mahal tea, coffee, branded shoes, anything, you name it, it is protected. Using cars, using laptops, mobile phone, pen, everything is protected. So how we can avoid it? We have to think about IP, why it is so important. We should know about it and we should protect it. So just importance of IPR, I would like to say that if you have a IP protected product in your market, definitely you will be recognized, and you will be you will get the incentive for new creation by the government, because you will get the certificate. The government will give you incentive to give the exclusive right. That is the if you file a patent, you will get the exclusive right. That is an incentive given to you. In short, this IP protection ensures the availability of the original products, and it enhances the economic growth and advancement in technology sector. Protection of intellectual property is very, very important to enhance the technology advancement. They are benefited for the growth of the business, because if you don't have IP protected product or the process or anything, nobody will come for making it, or the industries will not be interested. It enhances the company value. You may be aware about these IT companies, Microsoft or Google or Amazon, and all these companies, they have a more than 95% asset of the company is because of IP. Because of IP, they are fully protected, and the value of the IP is more than 95% of these companies. Other physical assets are only 5% or less than 5%. So this is the importance of IP. You can stop unauthorized use of invention for making, using, selling, and importing. Indication, if you have a patent protected product, or just you have filed application, you write on the product pending patent, this will support the sale of the product, and it reduces the possibility of theft of the important knowledge. So this is an importance. I just a little bit, I'm just summarizing it. What are the key advantages of securing intellectual property rights? IP plays a key role in driving innovation and economic growth, turns the innovative ideas into profit, definitely. Marketing of business goods and services. And if you have a patent for your technology or the product or the process, if you just put your application for funding in a government organization or in any other place or banks, or you will get the higher possibility of getting the loans, or the funding will be there because of the patent. It is a patent protected technology. So this is the weightage given to the IP. So improve the export opportunities for business. If you have patent, you will get the opportunity to have more business in other countries also, and secure unique ideas and creation. Accelerates the business growth, as I just told you. And IPRs strengthen trade, FDI, and technology transfer. Because if you protect the technology is not protected, the technology transfer will not be there. So what kind of IP is there? There are different kinds of intellectual property. Actually, patents, trademark, copyright, trade secret, designs, plant varieties, geographical indications, semiconductor, integrated circuits, layout designs, in the case of the devices and all. So these are the types of IP in all over the world, and India also. So we can have the inventions by patents. I will be talking much about the patents only. And I just want to inform you here, for each type of IP, we have the governing laws in India for IPR. You can see here, this is this Patent Act 19, Patents Act 1970, but other acts are either enacted or they have been modified during the period from when India has joined WTO. Because we have to change our laws, IP laws. So these the reforms were carried out by the government of India, and they have enacted several laws, as I am showing here in this slide: Copyright Act, Design Act, and the geographical indication and plant variety. All these acts are in place now. I just want to here show you the product here. Everybody knows it. Here, the Coca-Cola. Just I have taken a very simple example here. One product can be protected by many IPs. This Coca-Cola bottle is protected fully. You can say the formulation, it is a trade secret. Everybody knows it. Nobody knows the formulation of the this Coca-Cola product. So this is a trade secret. It is protected. And trademark, Coca-Cola itself is a big trademark, and design registration is for the bottle, and patent may be for anything which is used here, glass or any this paint or this thing, they are maybe protected. And design of the bottle itself is a protected design. It may be, I'm not saying for this thing, but I have taken a simple example to demonstrate here. One product can be protected by many IPs, all the IPs even. Just you see, the simple formulation is protected. How it is protected? This is a business product, so it is protected by many IPs. So, and one must protect the product if you want to place it in the market. many IPs. Just I have taken here an example of the car. You see, intellectual property protects this item, the car can be protected, or it has been protected. The technical feature of the car, any new technical feature of any part of the engine or any part of the car will be protected by the patent. And trademark, you know already, trademark of the product is Toyota or Innova or Mercedes or anything can be, it is a protected under the Trademark Act. And design, unique design, if new car comes in the market or any product comes in the market, it is appealing to the eyes. That means it is protected. Definitely it will be protected, because in the business it is to be registered. Otherwise people will copy it. And copyright, maybe any the brochure of the car or any written material is protected under the act. Different IPs can protect a single product. That means. And I just want to tell you here, the copyright protects the original literary, dramatic, musical, and artistic work. Cinematic film and all sound recordings, they are protected under the Copyright Act. But here I would like to mention here, I've shown here the laptop also, the softwares are protected under the Copyright Act, but it also comes in the non-patentable subject matter of the list in Indian Patents Act. But nowadays, what happens? India is very much concerned about the IP in the field of this IT. That is the softwares and other things. They want to protect it, but under the law, the software per se is not a patentable subject matter. But if it is embedded with the hardware, or if there is a technical problem is solved by the software, that is a patentable subject matter. So don't think it is not patentable. It is patentable. If you are using a software which is producing the technical effect, and which is used in hardware and producing the technical effect and solving the problem, there is a technical problem is solved by the technical and there is a technical effect using this software, then it is a patentable subject matter. So I just start from here. The geography, I have just shown here the geographical indications. You may be knowing so many things are nowadays geographical, they are protected under the geographical indication or they are registered under the GI Act. You can find out the Darjeeling tea, anything, all hundreds of things are now GI protected in India. The mangoes from Maharashtra, mangoes from other things, all fruits, agriculture products, they are protected. So I just wanted to mention here, I'm not going in detail into these things. Lucknow chicken craft, Banarsi saris from Banaras and all, they are protected. They are just protected by under the GI Act. I will be talking more about the Patents Act, development of Indian the patent system in India. It is very old in India. It started in 1856 at the time of a British period. The act was 1856, and design, and it was followed by Patents and Design Act 1911. And although Dr. Prasanna has already talked about the history of patent system all over the world, but I'm just specifically talking about the Indian system. During the British period, Patents and Design Act was in 1911. And after that, after the independence, we started thinking, the Indian government has started thinking about the reform of Indian Patents Act. And they made several amendments in this act and introduced working of patents, compulsory licensing, revocation of patents and other things in 1950 and 1952. And they were working very hard to frame new law for India in the interest of the Indian society. And after the working of these committees, Justice Iyengar Committee and all, they just brought this Patents Act 1970. And they just intentionally, they did not put the product claims for the food and drugs. and the products prepared by the chemical reactions. The reason was this was in the interest of the Indian society. And the term of the patent was only 7 years, and for other categories it was 14 years. So you can say the 7-year time is very less. During this, even the patent may not be granted by that time, and the term was expired. So what happened? What was the effect of this? In 1972 to 94, we were having in place the Indian Patents Act 1970, where there was no, or you can say very low level of protection for drugs and food, the products. And during this period, this pharmaceutical companies, they worked very hard and they became self-sufficient, and they created the facilities, they created the capabilities. And during this period, they started exporting the generic medicines to the world. And large number of developing countries were depending on the cheaper medicines from India. And you know, already India is a world pharmacy. And in 1990, the GATT came and WTO came into 1905. And what happened? India became member of the WTO. As for this agreement, I'm not able to hear. Yes. I'm not able to hear here. Okay, should I go ahead?
Yes, ma'am.
Okay, so what happened? WTO came, and then there is a TRIPS agreement, that is Articles 27 of trade-related aspects of intellectual property rights. This TRIPS agreement, we are the member of WTO, so we have to we have to reform our this IPs just to include the product claims. And then we started thinking, and then in 1999, the mailbox applications were started, and EMR, exclusive marketing rights, were also provided. And term of the patent was increased from 7 to 20 years, as for other technologies also in 2002. These phase-wise amendments were carried out in 1999, 2002, and 2005. In 2005, we were having amendment where the product patent for food and drugs and chemical reactions were included. So, and one more section of Indian Patents Act was section 10, disclosure of source and geographical origin of biological material. If we are using a biological material, it should be included in the specification. It should not be kept secret because of several reasons. Now, this is just, I'm summarizing here. The IP laws were enacted during this period, when after the WTO, and amendments were already done. And IPR policy, I talked about in 2016. I just want to mention here in CSIR, IP unit was there since inception. We were having, the government was very much concerned about the protection of IP in CSIR. That time even when CSIR was established. And this unit IPU is now, it is called IPU. It was there, a patent unit only. Now we have different kinds of IPs, so it has changed now. Name is changed, but it is there. It was started in 1942, and we are just filing the patent application and other IPs, trademark, copyright, design, everything we are doing it. So I just want to make here why patent protection is required. Actually, there are several reasons for that. Because it protects the invention. It is a creation of mind. When you are creating, nobody can touch it if you are protected. So if you have to, you have a right, exclusive right given by the government, you are protected. So it protects the invention. To use the invention, the philosophy of patent system is to disseminate the scientific and technical information, to encourage the incentive activities in the country and the society. And that will develop the technical field and also develop the industries, and it will be benefit to the society as well as to the nation and other nations also, and to the world actually. Because what will happen if you file the patent application, it will be in public domain. If you keep it secret with you, it will not be disseminated. You have spent a lot of time, effort, money, and everything is spent on it. And if you don't bring it to the public, it will not be useful. Or if you just publish it, it will be useful for you, but it will definitely, you will get the recognition and everything, but it will not be the protected. So this is the philosophy of the system, patent system. It has patents has two important roles. Essential role, as I told you, bring out the invention in the public. Because why the government is giving you the exclusive right? It is because you are disclosing the invention to the public. It is to be written in the form of the document and submit to the patent office. So the incentive is given, and that information, when it comes to the public in public domain, it encourages the incentive activities for benefit of society. So, and there are ancillary roles of the patent are function of quality assurance, credibility addition, advertisements, and security assurance, and exclusive industrial working. You are right. What patents promote innovations? How they do it? Because they are giving the strong exclusive incentive to the innovator or the creator of the product in the market. Probably thinking they want to put the product in the market. And companies may not be prepared to invest in costly clinical trials without exclusive right. If you don't have any protection, or it is not patent protected, or then companies, in case of the, definitely they will not come forward to do the clinical trials. If it is protected, they will have to have the exclusive right with them. And another is, as I told you, the access to latest information in the patent, and it will advance the science and technology. And patents do not do what it does not do. If you have a patent, it does not. It means you should not think like that. If you have a patent, you can stop everybody. No, you can stop everybody, but it is not giving you right to use it. Because if you have a patent for a drug, you want to make it, you have to take the permission from the authorized from the authorities, like drug controller of the patent, the drug controller of India. You have to have the authorization from them. If you have a patent, it does not mean you can market it and you can manufacture and put in the market. No, you have to have the permission from the drug controller. So all clinical trials are to be done. Patent does not mean you are allowed to practice the invention. No, you can exclude others to make the invention. If somebody is using your invention, you can stop them. But you cannot use yourself until you have the permission from the drug controller, or the other for other products, they have to take the permission from the respective authorities. I just want to here discuss about the little bit how it works in the IP offices. They come under the Ministry of Commerce and Industry, Department of Promotion of Industry and Internal Trade. The Controller General of Patent Office is here, and he is in charge of all these IP offices in India. And there are 4 IP offices: the Kolkata, Delhi, Mumbai, Chennai. Trademark registries are there in all IP patent offices, and one more is Ahmedabad. Design registry is in Kolkata only. GI registry is in Chennai. Copyright registry Delhi. And this is RGNIIP, Rajiv Gandhi National Institute of IP. This is in Nagpur. So this is all the IP related system here. And since you are your institute is in Maharashtra, so it should find in Mumbai. All the IPs should be filed in Mumbai patent office. Just how we can file the patent application? There are 3 ways to file. You can prepare the document, go physically to the patent office and submit the document. You can go to the patent office and submit your document here physically. Another is electronic filing. Electronic filing is simple. You just sit on the portal and just file the application, pay the fee, and the application will be filed. or by post. If you don't have any other means, you can send it by post also. These are 3 means you can file, but electronic is the best one. And you can have the reduction in the fee, 10% of the fee is reduced by electronic filing as compared to the physical filing. Even they promote only the electronic filing, the patent office. Filed, it should be the appropriate office of the patent office shall be in the head office of the office, or because there is a territorial limit. 4 patent offices are there in 4 zones: North Zone, South Zone, East and West. So all these, there is a limit to file. If you are in a Maharashtra, then you should not file application in Delhi or any other patent office. Otherwise, it will be invalid. So is like in CSIR is having the labs are all over India, 38 laboratories, and all the IP, it comes to IP unit, that is IPU, and it comes to us only, and then it is filed in Delhi patent office only, because we have a headquarter in Delhi, and so it is filed in Delhi patent office. Now, this all information is already there in on the website. These are the zones. Actually, these states are covered: the Chennai patent office, Mumbai patent office, New Delhi, Delhi, and Kolkata. They are. If you file the wrong application, if you are sitting in Mumbai filing in Chennai or in Delhi, then it is a problem. So please find out the right place where you want to file. And I just want to tell you the territorial rights. There is no world patent. People may think if you file one application, it will cover the whole world. No, it is not like that. Need to file patent in each country separately. And if you have filed the application in India, you have it right only in India. If you have filed the application in US or any other country, Canada or any neighboring country or any place, you have limited right on that territory only. We cannot say I have filed the application in India and I want to stop someone using my invention in US or any other country. No, you are given rights for India only, or if you have filed the application in US, you have right in that country, in US only. You cannot stop making the product in India. So please keep in mind all these things when you are making application. Now, I just want to tell you here, there are systems for filing the international filing, Patent Cooperation Treaty. That is, we are member of WIPO, so World Intellectual Property Organization, that is placed in Geneva. So Patent Cooperation Treaty is a treaty where you have to file the application under this treaty, and single application will be filed, and the member countries, it will be taken up after a period. Actually, this is whole PCT is a long process, so I may not be able to cover here, but there some if you file application. If you have a PCT, you can choose the countries where you want to file the application later on. And Paris Convention is 1 year window. Suppose you file the application today in India, you have 12 months time to file application outside India, and the date will be considered from the date of filing. So this is the advantage of filing the PCT and the Paris Convention application. So because it is difficult to manage all the applications at one time in all countries if you want to file, so it is better to file application under PCT and then choose the countries later on. So your priority date is already means taken care. You need not to worry about the priority date. The first day when you are filing the application in PCT, that will be your priority date. And then Paris Convention, within 1 year, if you want to choose, suppose if you want to choose only two countries, then you file the convention application. So there are different ways of filing actually. It depends on the country to country, as well as depends on the type of application you want. And what is a patent actually? It is essentially a legal right to the inventor or the applicant by the government for his invention, which is either a process or a product. It is a legal document issued by Patent Office and granted for a limited period of time, that is 20 years from the date of filing of the application, and to the limited territory. As I told you, it is only if you file the application in India, it will be only in the Indian boundaries. And patent enables its owner to exclude others from using the invention in the territory for which it has been granted. So this is exclusive right actually. You can stop the others for making or manufacturing, using, offering for sale, selling, importing and distributing the product or the process. If somebody is using your process for manufacturing the products, it will be stopped. You can take action against those people if somebody is making use of this. As I told you, this patent document itself is a techno-legal business document. It protects for 20 years. So nobody can make use of your invention without your permission. Even if you license it, you will get the royalties from it. You can block the competitors. And after 20 years time, the term of the patent is over. The product will be, or the product is free to, anybody can use it, or the process can be used by anybody. You cannot stop it after 20 years. That is called as term of the patent. You might have already experienced, or you may be knowing already, generic companies, they sell the product at much cheaper rate because the patent term is already over. They start making it, anybody can make it and then sell it. So now I just want to just give you the flavor of the Patents Act actually under section 48. The definitions of the product patent and process patent. You may be knowing what is product and process. The exclusive rights to prevent third parties. These are the definitions given in the Patents Act. Without the consent from the act of making, using, offering for sale, selling or importing for those purposes in India. And similarly here, the process patent, using the process and from the act of using, the offering for sale in India is these are the rights given under the act. So I just want to tell you, this is the enforcement right. Owner of the patent is having two kinds of rights: licensing rights and the enforcement right. If you have a patent, you can license it for using the invention to anybody who is having the capabilities of making a product. You can license it and then you can have the royalties, or you can have the payments from the licensor. And you have enforcement right, but they are limited to the scope of and location and duration. If you have a patent only in India, you have the limited scope in India only in India, not in other countries, location and duration. And for 20 years of the time, if suppose it is not maintained, this patent after grant, it is not maintained. I will be talking about that also. Maintained for 20 years, you have to pay the fee to the patent office. If it is payment is not made, then you may lose the rights. Exclusive rights you will be losing. So you don't have that right to stop others. Anybody can do it. Now I want to tell you, patent is not an absolute right. You are getting the exclusive right, but it is not absolute right. That means if you are having the patent is given by the government has a right to use it. In this pandemic time, you have already seen the government has a right to manufacture the product in the interest of the public. They can take they take the custody of the patent and then give instructions to the manufacturing units or manufacturing companies. They can produce the product and bring the product in the market in the interest of the public. And during this pandemic period, you've seen the vaccines and diagnostics methods and all these drugs, they were manufactured by the companies on the instruction of government. So if you have a patent, it does not mean patent can be taken up by the government for the public interest, and definitely you will get the benefit. The incentive will be given to the creator. And just this is, you can just understand it like this. If you have a land as a property, you have a land and government wants to make the airport in that land, or the farming land is there, expressway is to be made by the government, they will acquire it. They will acquire and then make the payment to the owner of the land. So this is similarly here in patent. What happens? The patent's exclusive rights are given to the creator or the owner of the patent, and they are compensated by the government. And for nobody is going to stop you for the experimental purpose, research purpose, teaching purpose, and the government hospitals, they on the instruction of government, they can be distributed. So that is the reason it is called, it is not an absolute right. It is a exclusive right, but not an absolute right. As per the Indian definition, Indian Patents Act, the invention. What is invention? Invention means a new product or process involving inventive step and capable of industrial application. Three things: the product should be novel, or the process should be novel, it should be inventive, and it should have industrial application. Some utility should be there, otherwise it will not be called as invention. Inventive step. What is inventive step? How to judge the inventive step? This definition is given: means of feature of an invention that involves technical advance as compared to the existing knowledge or having economic significance. That means if you have a process or the product, how to judge this? The feature of the invention should be there. Technical feature, it is making the knowledge advancement or having economic significance. Some significance should be there to make the invention not obvious to a person skilled in the art. These are the definitions already given. So what are the patentable invention, or you can say requirements of patentability? What is whether invention is patentable or not? It should be novel. It should not be published in anywhere in the world, and it should be inventive. This inventive step is a non-obvious, also called as non-obviousness. It should not be obvious combination of the known things, any product or process. It should not be obvious product or obvious process, and it should have utility. And it should be disclosed in the document or the patent document sufficiently to reproduce the invention. So somebody can make use of this invention. This is the actually philosophy of the patent system, to disclose the things in the patent document so anybody can use it. So these are the requirements of patentability. As I told you, the novelty of the invention will be judged. It should not be published, or it should not be available in public. It should not be published, or it should not be prior use. It should not be, suppose you are using the product in the market, but it is not protected, but it is in a public use, and it is claimed in some of the specification or any documented form, it will lose the novelty of the product will be lost. So this will prohibit the patentability requirements. What is prior art actually? When you take up any new project or you start any work or research, then you start the prior art search. What is already known? Any information disclosed to the public anywhere in the world is or oral communication by display or through public use constitutes prior art. It will be called as prior art. There are a number of ways to do it actually. It may be in the patent document or non-patent literature. As you are the researcher, you just want to publish it in a peer-reviewed journal or any place. If you just publish it, it will lose the novelty of the invention. And you have to find out whether it is a patentable and not go for the publication. The patent system serves two major functions: the disclosure. I would say you already know the non-patent literature, how to find out anything is known in the patent literature. You may be knowing patent information is also very important, but patent documents are very important because 2/3 of the content of the patent information is not disclosed in any of the papers, the publications, other publications. So patent documents are much more useful for doing research. So when you take up any project, you must do the prior art search in the patent documents. How to do it? There are freely available databases: USPTO, EPO, European Patent Office, WIPO, World Intellectual Property Organization, JPO, Japan Patent Office, and then Indian Patent Office. All these patent offices, they publish the document. So even if you just search in EPO, EPO is having a vast compilation of the databases. And PCT applications are also there in WIPO, EPO. So you just do the patent search in EPO or WIPO, Indian Patent Office also. So you can find your relevant documents, what is going on. And there are certain commercial patent databases, STN, Thomson Innovation, QPAT, and all, you have to pay for that. And these are also very useful when you are doing patentability searches. And you see, patent documents are very much a structured document, and they are classified by patent offices. All these databases of patents, they are classified. International patent classification is there. You can find the things very nicely in these patent documents, and do the and establish the novelty and inventive step. Most relevant document you will find in the using this patent classification system. Now, I think I will be talking about the anticipation by public display. If you are publishing as a researcher, you are always excited to publish the document, or as soon as you are ready with the results and you are excited to publish it, because students may be submitting the thesis or for career enhancement, you are in hurry for publication. So, but you should keep in mind before publication that if anything which is patentable subject matter in this publication may hinder for grant of patent application, if you wish to file the application after the publication. So I would spend 1 or 2 minutes here. Indian Patents Act 31, under section 31 of Indian Patents Act, says there is a provision to have a grace period of 12 months. Suppose accidentally you have published it. You have published the content of the patent application in a publication before filing the application. Then you may say there is a grace period of 12 months and you can file the application. But actually, under section 31, it is given here what will not be hindering is display of invention in an exhibition notified by central government in the official gazette. Only that has a 12 months of grace period, or publication of invention in consequence of above said this exhibition. Use of invention during the exhibition, paper read by inventor before a learned society or published in the transaction of society. You are having a meeting or conference or in a science congress, you just went there and then you have presented the paper. Maybe because this provision of the section 31 does not elaborate anything. Even the definition of learned society is not given over there. So it is advised not to publish, because we don't know the examiner, the controller of the patent office, how they will examine. So it is prohibited. Actually, application will not be anticipated if it is filed within 12 months from such display. It is like this only. But if it is not notified in the central government official gazette, then if they will not be considering it. So this is a very restricted grace period. Very restricted grace period, and it is a confusing always to the examiner. It depends, examiner or controller to controller. They just take according to their wish, because it is not elaborated in the Patents Act. So it is advised not to publish it. If you wish to file the application, after filing the application, you are free to publish the content. In case of the public working, if you have a suppose any drug which you want to do the reasonable trial for the clinical trial, it has come to you. You may start it. You may start the clinical trial, but within 12 months from the date of clinical trial, application should be filed in patent office. Then it will not be problematic for grant of the patent application, because this section 32, this indicates that if the patent application is filed within 12 months from the date of priority, then from the date of public display or public working, it will not be considered, or there will not be a problem for the grant of the application. Now, I just want to talk to you regarding this novelty issue. Actually, these are three things: novelty, inventive step, and the utility. I'm just taking some examples of novelty. Suppose there is an invention, compound, the fumarate salt of compound X, useful for treatment of diabetes. Suppose this fumarate salt is disclosed in a prior art, but there is no actual example is given. It is not a specific disclosure is provided in the the document. Even then, it will be considered as the prior art, because it is just one line is there, fumaric acid salt, fumarate salt. Then you may not be, you will be considering it as a prior art. So novelty is lost because it is already there in the prior document. Now, how to judge the inventive step? Any technical advance, you have to critically analyze the inventive step. What are the features of the invention which are making the invention technical advancement is there, or there is any significance? Is there your invention is cost effective as compared to the products available in the market? Then definitely you will have your product is inventive. Makes the invention not too obvious to a person skilled in the art. Suppose somebody wants to make the product which you have made. Is it possible to make this product looking at the prior art already available to the public and come to the conclusion as you are looking? Then it may not be patentable. I will be taking more examples of this. I'm just taking one example here. This defluoridation method of the water. Actually, somebody wants to make the patent application. These are three things: calcined eggshell powder added to the fluoride content, removing from the water. And then these three components, eggshell powder and then aluminum nitrate, alum. These three things, they are combining in these steps while doing this, the defluoridation of water. They are removing the fluoride content from the water using these three components after some processing. But if you see the prior art, if these three things, they are already there separately in single steps. Somebody has reported in the papers calcined egg, use of calcined egg shell powder. Somebody has used aluminum nitrate, somebody has alum. Then combining all these, looking at the prior art, maybe the inventor may be motivated to combine all and get the results. It will not be considered as a inventive process. So this will be having the problem. So when you judge the inventiveness, you have to judge the prior art first. Analyze critically the prior art first. What is already known and how a person who is skilled in the art will look, and can he come to the conclusion which you are coming? Looking at the prior art. If yes, then it will not be inventive. So this is the way actually we in our patent analysis we do. So industrial application, third thing is industrial invention should be useful. It should be capable of being made or used in any kind of industry to fulfill the criteria of patentability. What is the subject matter of patent? I just want to discuss here. Anything can be patented. Machine, system, process, article of manufacture, any biotechnological inventions. I will be talking more about that. Chemical substances, drugs, and all the process and products, they are patentable subject matter. Anything can be patentable. I've taken some examples. Any simple pen, yes, definitely. If there is an improvement of the pen, suppose if you have a ink in this pen which is never made by anybody, it is shelf life of this ink, or you need not to worry once you are filled. It will you can use it for longer period, something like that. Anything can be patentable. BGR34, you may be knowing, this is a drug for diabetes, and it is already in the market, and it is a patent protected. This is a formulation actually plant based. This is also a drug in the market. This is Centroman. It is used. It is in the market also. Anything can be protected by this thing. Technical feature of the invention is protected. Any article, apparatus, machinery, or anything, pharmaceutical product, composition of matter, any thing is patentable when there is a human intervention. It is a patentable subject matter. Now come to the, I just told you the patentable subject matter should be novel, inventive, industrial application should be there. Without industrial application, it will not be patentable. Sometimes when I was in CSIR, some of the applications, we receive they are novel, they are inventive, but they are not industrial. There is no application is provided in the specification because the inventor, what he thought, this is a side product obtained during the reaction. Some chemical was side product, was isolated as a side product. It was not intended to make, but it is a side product and it is produced and it is a novel product. An inventive step is there, but utility is not established. Then we cannot file the application because some utility should be there. Then it will be patentable. And very important, section 3 and 4. I will be talking more about it. It should not fall under section 3 and 4 of the Indian Patents Act. What is section 3 is a non-patentable invention. They have elaborated what are non-patentable inventions. And under section 4, what is safe? Inventions relating to atomic energy, they are not patentable subject matter. So I am not spending time for section 4, just the radioactive compounds and all these are not patentable. But section 3 is very relevant for the researchers here. Section 3, what it says under the Act, invention, they have given list of the inventions which are not patentable under Indian Patents Act. Although they may be patentable in some other countries, but in India we have list, and similarly some in other countries also they have list of patent. They will not be regarded as patentable invention. But I'm not going to read it. I'm just telling you, if we have an invention, we have to critically analyze. We should not be afraid of afraid it is not a patentable subject. We have to find out the ways of making it patentable, how to do it. So it is very much necessary to understand what is not patentable. Everything is patentable, but we should know what is not patentable so you can make out what is patentable out of that. So any invention frivolous, obviously contrary to established natural laws, public order, and they are not patentable. Mere discovery of scientific principles, formulation, living, non-living things are not patentable. As such, they are not, if they don't fulfill the criteria. New form of a section 3D is very important for the researchers because it is much debated and a lot of drugs, they fall under this category of section 3D. New form of a known substance which does not result in the enhancement of the known efficacy of the substance of the mere discovery of any new property or new use. I'm not reading, but when you read it very carefully, and then you will come to know it is very relevant section 3D for the drug development. And another thing is section 3E, mere admixture resulting only aggregation of the properties. Suppose if you mix the 2-3 components and come to the same properties and there is no advantage, it will not be patentable. Arrangement, mere arrangement, rearrangement of duplication of devices and all. Method of agriculture and horticulture, they are not patentable subject matter. Although the equipments and all these things are, don't think it is not patentable. You have to see what is patentable, how we can make it patentable. Here, if you read agriculture is not patentable, it is not like this. We have to think how it can be patentable. Yes, there are number of patents in these fields also. So this is actually job of the IP professional to find out how to make it patentable. Any process of medicinal, surgical, curative, prophylactic, and these methods are not patentable. Method of treatment of human beings or any similar treatment for animals they are not patentable. They falls under this category, but it is really very important to make it patentable. This is the IP professional job. And method of treatment of plants is removed from this. It is patentable subject. Method of treatment of plants is a patentable subject matter. Plants and animals in whole, as such, if you say I want to you have isolated a microorganism which is already existing in somewhere, and you just want to have the patent for this, you may not get it, but for process of isolation you will get it. But you have to show the microorganism which you have isolated is different. It was not existing in the same form, or any genetically modified microorganism is a patentable subject matter. So we have to critically analyze the what is not patentable. Then you will be in position to get the actually what is the invention in my case, and then file the patent application. Mathematical business methods, they are computer related. As I told you, computer program per se are not patentable. Algorithms are not patentable as per the Patents Act in section 3K. But now the guidelines are being issued by the Patent Office to how to make them patentable. And they are saying the program per se, computer programs per se will not be patentable. But if you are solving some problem, there is a technical effect because of the program, and then solving the problem, it is a patentable subject matter. So this is a whole list of things which are given in section 3. 3P is important for you as a researcher in the field. An invention which in fact is traditional knowledge is not a patentable, because lot of things they are coming from the traditional knowledge. It is not like this. Traditional knowledge based inventions are not patentable. They are patentable, but you have to write in such a way and provide the data what you have done after the traditional knowledge. If you say I want to use turmeric as a wound healing agent, it will not be patentable because it has been used for so many years. So it is already known. So novelty is not there because it is already known, and it will not be patentable subject matter. This is very simple. But if you have done something, if you have isolated some compound from the extract of the turmeric, and then that was novel compound, it has some more effective utility, then you will get the patent for this. And section 4, as I told you, atomic energy related patents are not patentable. Inventions are not patentable. Here I just want to talk about the Article 27 of TRIPS, Trade Related Aspects of Intellectual Property Rights. Actually, we are members. India is a member of this WTO, and so there is a provision, Article 27, where members may also exclude from patentability. They have given the list of the technology, the methods, diagnostic, therapeutic, surgical methods for the treatment of animals and humans. They can exclude it. Plants, animals, other than microorganisms. Other than microorganisms means microorganisms are to be protected. But it depends on country to country. They have to amend the law. So we have amended our law. India has amended the law, and they have excluded the diagnostic, therapeutic, and surgical methods are not patentable in India. I just want to discuss here main categories of patents in medical field. What are the patents actually we can have in medical devices? Lot of medical devices, all the medical devices are already patent protected. Actually, we should we have a huge market for medical devices. Every day we are having new things in this field. So all the devices which are used by the physicians and hospitals and other service providers, whatever they are using, all the instruments in the devices, surgical tools, surgical equipments, all these things are patentable subject matter. So don't think doctors should not be involved in this activity. They are very much producing the inventions. They are having the inventions there in hands. Drugs and food delivery devices, the pacemakers, and everything, whatever is used in the medical field, in the form of device, it is patentable subject matter. There is no question about it. It is a patentable subject matter. They will be patented. They can get the patent for those chemical products and pharmaceutical drugs. These are the most crux of the patents for the medical field. Actually, I will be talking more about this. Healthcare technology, as I told you, the softwares in healthcare technology, whatever they are using, they are patentable subject matter. Medical, and because you using IT, using software, you are producing the products, or you are making facilitating the process in the hospital. That is also a subject matter for the patent. You can have the software for facilitation of the hospital, as I have seen or I have heard about the AIMS has developed the system where you need not to keep your old records. You just see on the portal, it is already available. So this is this is because the software is developed like this, and this is patentable subject matter. Medical and surgical methods, they have patents also, but may not be surgical methods may not be patentable. Medical and surgical methods in India, but in other countries they are patentable subject matter. Like in US, regenerative medicines, stem cell therapies, as well as tissue transplant technologies, including knee cartilage and everything. Regenerative medicine, you know much better than me what it is regenerative medicine. Patents are there in these fields also, may not be in India, but in other countries, like in US. Claims for pharmaceutical products. For pharmaceutical products, what you can claim? You can have a product claim, process claim for all new chemical entities, formulations, compositions, combination of drugs, new kits. Every day we are having some new kits in the market for testing purposes, or recently for COVID, different kinds of kits were there available, and these kits are patentable subject matter. But method of testing is not there. Yes, method of testing is also patentable. Claim using the kits, it is a patentable subject matter. Claim for process of preparation of drug, as I told you already, it is there. Claim to new property or new use of a known substance is there. Not in India, but in other countries. Method of treatment of diagnosis of disease of human beings or animals is patentable in India, and is not patentable in India, but it is patentable in US and Europe and some other countries also. So how the biotechnological inventions, they actually till 2002 in India, patents were not granted in biotech field. Living entities of natural or artificial origin, they were not allowed. And biological material having replication properties and derived from such material, nothing was allowed actually. If you have any of the plant origin or any natural source, the biotech cases, they were not allowing. And after that, the one important case actually, although the process of preparation of compound X, suppose if somebody has isolated an antibiotic from fungus, this process was allowed that time also, but the product was not allowed under the Act. Process was allowed, the product was not allowed. So, after 2002, actually, in 2002, this a process of preparation of a live vaccine for protecting poultry infection refused by the controller on the ground that process involves the living organism. It was refused by the controller. So what happened? This case was came to High Court, Calcutta High Court, and decision was given that it should be allowed. After this, the amendment was carried out, and then wherein the biological and biotechnological, microbiological processes were included in the scope of the chemical processes. So as the chemical processes were allowed, and these were also allowed after that. So there is no problem nowadays for the live vaccines, it is allowed. Claims for biochemical, biotechnological inventions, what kind of claims we can have? We can have the polynucleotide gene sequences, polypeptide or protein sequences, vectors, and whole list is there. They are allowable. Biotech inventions, they can be allowed. but it depends on country to country. In India, some of the inventions may not be allowed, but not, we should not think biotech inventions are not allowed. They are allowed. Some of the things are not allowed depending on the broadness of the scope of the invention. And method of diagnosis, suppose this method of for diagnosis of a label of glioblastoma, any cancer or anything, it is allowed in many countries, and actually this case was filed in CSIR also, and the CSIR has got many patents on the glioblastoma methods, and the kits and all these patents were granted in many countries. And diagnostic kits, tests, they all are patentable subject matter in the case of biotechnological inventions. So we should at least try to analyze what is the subject matter for patent and how we can make an application. What you can do, you can file the application having all kinds of claim in India. Whatever they will not allow, we can deal it after the during the prosecution stage or the examination stage. The amendment can be done, but at least we should file the application. And in other countries like in US, you will definitely get all these kinds of patents, and to the some extent the EP is also broader than India. I just would like to here discuss about section 3D, as it's very important for drug discovery, as this section is for introduced in the Patents Act 2005 to stop the evergreening of the patents by the companies. Well, minor modification of the original drug, they just filed a patent different application and then again application. So to stop that, this section 3D was included. So what happened? The what it says mere discovery of new form of a known substance which does not result in the enhancement of the known efficacy. So it is very important. If there is enhancement in the efficacy of that new product, then it will be patentable subject matter. Suppose any cancer drug which is going to expire, the term of the patent is expiring, the company will, what they will do, they will make another salt or an enantiomer or ester or ether polymorph and then file separate application, and they will have monopoly again for 20 years. So what the section 3D says, if there is enhancement in the efficacy, then it will be patentable subject matter. I will be giving you the example here. Actually, what they do, legal requirement in case of the pharmaceutical salts is not, or the any of the product which is of the falling under section 3D is not different from any other technical field. It should fulfill the requirement. It should technical information needed to satisfy these legal requirements. That what is that? Novelty, inventive step, and disclosure. These three things should be there for the any product or process. So if this is missing, it will not be patentable subject matter. I just want to say here 2-deoxyglucose for the treatment of COVID-19. I just simple example is because everybody knows it. Is it patentable? If DRDO has come out the use of the 2-deoxyglucose for the treatment of COVID, can we have the patent for this? No. Molecule is already known, well known in the prior art, but use is new. Use of this drug 2-deoxyglucose for treatment of COVID is new, but it is falling under section 3D. So it is not a patentable subject matter. New use of a known substance. Method of treating COVID-19 2G drug is not patentable because method is also not, because if method of treating COVID means if you are saying this drug should be taken 3 times or 2 times with the food or without food. So this comes under the method of treating. So this will also attract the non-patentability under section 3I. Method of treatment is not patentable. So what we can do, we can, how one can make it patentable? How can it be patentable? You can make a new salt of this molecule or any synergistic formulation with any other component which is showing better effect than this molecule. And it should be non-obvious combination of other drugs because if it is an obvious combination, then it will not be patentable. So non-obvious combination with other drugs will be a patentable subject matter. So this is just simple example to make it clear how it can be patentable. You may be knowing this Novartis case, this Gleevec case. It was for a long time. It was under discussion. It was filed in India. This is a leukemia, myeloid leukemia, treatment of chronic myeloid leukemia. It is a Novartis case. So this molecule was new, and they have filed the application for beta crystalline form of methyl sulfonic acid addition salt of imatinib. It is called imatinib, and process for preparation thereof. They filed the application in Chennai Patent Office in 1998. And beta crystalline form they have prepared. That means this other forms are already known. So molecule was known, but beta crystalline was not known. Beta crystalline form of this molecule was not known. So they filed the application in many countries, and they got the grant in many countries also, in US particularly. But in India, India was saying this is falling under Section 3D of Indian Patents Act. So we will not grant it. So this case went up to the Supreme Court. And what they said, this beta crystalline form is having better physical properties, more beneficial flow properties, better thermodynamic properties, lower hygroscopic than alpha form. So they were trying to save their, and in the hearings and appeals, they were submitting this. But then it was critically examined in Patent Office and the High Court and Supreme Court, and they analyzed. And then what they said, it is falling under Section 3D. And they said improved physical attributes cannot be considered as enhanced efficacy, because and also said 30% enhancement in the bioavailability is not enough to show the better efficacy of beta crystalline form. They showed the data, there is an enhancement in the bioavailability, 30% enhancement, but efficacy was not there. Enhancement, they did not produce any data for the enhancement in the efficacy. So it was refused by the Supreme Court even in 2013. And another thing was, it was already there in their patent application. Already it was disclosed actually. I have seen from my eyes also when I was examining this case, just for the curiosity. This miscellate was already there. So this is also a negative point for them, and it was mentioned in their documents submitted to Patent Office. When you have to submit the documents to the Patent Office, it should be very carefully analyzed what you are submitting to Patent Office. It may be negative for any time during the term of the patent. So this is just one example I want to show you. The crystalline form does not mean it is a enhancement in the efficacy. You have to show the data. As a clinician, you have to produce the data. You have to produce the data showing them the enhancement in the efficacy. It is required. I just want to give you another example here. It is a amlodipine here used for treatment of hypertension, and this is the enantiomeric form of the this molecule amlodipine. So enantiomers also comes under the Section 3D of Indian Patents Act. We can have the patent for this enantiomer if we provide the enhancement in the efficacy data, then it will be patentable subject matter. I just want to, I think, elaborate. I have already done it, but simple way. First thing is to identify the closest prior art. What is the closest prior art? And then find out the problem solution approach. Just what was the problem existing in the teachings or the prior art, and analyze those things. And have you removed any of the problems associated with the prior art by your invention? Then identify the distinguishing feature by which claim is by which the claim is novel. Your claim is novel because of these distinguishing feature of the invention. Then what is the technical effect because of this this novel feature? Are you getting any technical effect? Is there any improvement in the enhancement of the efficacy? So what was the problem solved, technical problem solved or a skilled person wanted to have the achieve technical effect. If you are able to get this answer, if no, then your invention is inventive, or if yes, then it is an obvious combination of the prior art. So this is the way actually we do it. What did this mean to the pharmaceutical salt? I just want to elaborate here again, because this is very important for the drugs. And as a clinician, you may be working on the drugs and researchers. So this is the invention actually you are claiming here. But if you are having a pharmaceutical salt or enantiomer or any new form of a known substance, then you have to have the two kinds of studies inside the body and outside the body. Inside the body as the physical attributes of the molecule, and inside the body, bioavailability, efficacy and solubility and all these things, toxicity and everything is to be studied first. And then you have to, if you are not in position to include this information at the time of filing the application, because it takes time, then you should be ready with the data. So that can be used at the time of prosecution of the application. It is not necessary to use just include this information at the time of filing, because I know it is time taking. And then just include in the prosecution of the application. It is very much required. You have to disclose the full characteristic data of the compound if you have a new form of a known substance. Then biotechnological inventions, claim for discovery of any living thing, non-living thing occurring in nature may not be allowed, but products such as microorganisms, nucleic acids, enzymes, compounds which are directly isolated from nature may not be patentable. But if you have modified them, or you have characterized in such a way, you are giving the use of that modified, isolated and modified, characterized novel products not available in the prior art, having unexpected activity or function may be patentable, depending on the prior art. Because what prior art says, then what you have done after that, then it will be patentable. Genetically modified microorganisms are patentable. There is no problem. Although definition of microorganism is not provided in the Patents Act. I told you this mere admixture resulting only in aggregation of properties may not be patentable. Like a composition of innovative combination of dormant spores of nature occurring of these two components, fungus, then if there is no synergy, you have to show the data that there is a synergistic combination, then only you will be getting the it will be patentable subject matter. If you just mix it and then there is no unexpected result, then it will be granted. I'm just giving very simple example: paracetamol, antipyretic, and brufen combination. Normally, it is available in the market now. I think it is banned. Combiflam. If you say this paracetamol is antipyretic and brufen is analgesic, you are mixing and producing a combiflam. Is it patentable? It will not be patentable, because these both components are already known to have these properties. And combiflam, if there is enhancement in the efficacy, there will be it will be subject matter for patent. But if you are using antipyretic and analgesic for treatment of cancer and nobody has done it before, it will be a patentable subject matter. So biotechnological inventions in EPO, how they do it, actually it is biotech inventions in European Patent Office is much broader. Actually, patentability of microorganism in EPO as compared to in India is more, because they have given clear-cut microorganism definition. Includes bacteria, other unicellular organisms which can be propagated and manipulated in lab, including plasmids, virus, unicellular fungus, algae in human, animal, and plant cells. They have placed it in the this definition, so it is very clear over there. So we can have a claim for those things. Biotech inventions, provisions of Indian Section 3J, plant and animal they are not patentable subject matter. Seeds, varieties, they have separate Plant Variety Act is there. So we have a protection for these things, for plants. Animal as a whole or any part of this is not patentable in any of these acts actually. And modified microorganisms are patentable subject matter. However, process of isolation of microorganisms is patentable. Only modified microorganisms are patentable, and their process of any of microorganisms is patentable because as per section 3C. And method of producing at least one substantially pure, I have just given one more example here, 3J. I'm not reading now, I think. Now, let me come to the biotechnological inventions, provision of Indian Patents Act, method of treatment. These are whole list of method of treatment. Things are surgical methods, curative methods. This medicinal methods and diagnostic methods are not patentable therapeutic. But they have excluded the cosmetic methods. If you are purely on for cosmetic purpose is not therapy. So it is a patentable subject matter. For example, method of fitting braces to the denture for cosmetic reason is a patentable subject matter. It is a patentable subject matter. If you are having any of these surgical methods, curative methods, they will not be. Removing of plaque from teeth, the vaccination method. Vaccine is patentable, but method of vaccination, suppose it is a it should be injectable or it should be oral or in a patch form, anything. The method will not be patentable, but the vaccine itself is a patentable, either a form of injection or oral or patch. That thing, the kit is patentable or the product is patentable. So these methods, I think if they have excluded, we are not losing much actually. We cannot stop people or doctors to make surgeries because they are excluded from this kind of infringement activities, or they should not have any pressure. That is the reason they have excluded these things. So they can use any of these methods for their treatments. But instruments used for surgery and all they are patentable subject matter. Patentability of diagnostic methods in EPO, they are patentable actually under EPO. Sorry, not patentable. Like in India, we don't have patentable. But treatment of body tissues or fluids after they have been removed from animal or diagnostic methods applied there are not returned to the same body, then it is a patentable subject matter. For example, treatment of blood for storage in a blood bank for testing of blood sample is not excluded from patentability. Suppose if you are improving the shelf life of the blood bank used in the blood bank, it is kept in the blood bank. If you are increasing the shelf life by doing something to the blood, it is a patentable subject matter because it is outside the body. It is not inside the body. So it is a patentable subject matter. Similarly, I think in India also it will be patentable because it is outside the body. Similarly here, another example I'm giving here, the treatment of blood during dialysis and the blood being returned to the same body is excluded from patentability. So these are few examples I'm just giving, making the this thing. Another thing, the section 3P, the traditional knowledge. Traditional knowledge is not patentable as such. For example, the wound healing property of turmeric is, as I told you already, is not patentable. And Vidania somnifera or any other thing, because it is already known in the country for centuries. So it is not a patentable subject matter. But if you have done something which is very important after the traditional knowledge, although you are getting the clue from the traditional knowledge, but if you have your intellectual input in this, you have given intellectual input to come to the conclusion of the invention, then it is a patentable subject matter. For example, this patent, two Indians, they filed the US patent application for the use of turmeric for wound healing property. It was granted in 1995. And then it came to the to CSIR, noticed this patent, and then it was challenged by CSIR. and produced so many documents to US Patent Office in 1996, and it was submitted to Patent Office, and they were this patent was cancelled by US Patent because they showed how it is known already in India for centuries, how you can patent the use of the turmeric for the prior art, how patent will be granted. So after this case, this is a landmark case of CSIR or for India actually, and it came to mind, why not to prepare traditional knowledge digital library. So the creation of digital library for the traditional knowledge is done, and it is the property of CSIR. They are working on it, and all the big patent offices, US Patent Office, this EPO, Canada, and many patent offices, they are having access of CSIR traditional knowledge digital library to assess the patentability of the patent inventions. Therefore, they grant the application. So I think this is one more example. Just I have shown here the Ayurveda formulation. The Vastajan filed the application, but it was granted by a patent office, Chennai Patent Office, and it was revoked because of the novelty issue, and EP also did not grant it. I just want to give you here one more example here, how we work in CSIR. Patent filing and prosecution needs teamwork. It is not like the inventor should do everything or the IP professional should do everything. It is a teamwork. Here we work together in CSIR laboratories and ask the inventors to provide the information whenever we need it. This is just one success story I want to share with you. Dental implant case. Actually, this is first indigenously designed dental implant in India, and Indian and US patent applications were filed by CSIR. And inventors were from IIT Delhi, and the doctors, engineers were from IIT Delhi, Maulana Azad Dental College doctors were involved, and CSIR funded this project, and we worked together. And they after a very hard work of all three, CSIR as well as Maulana Azad doctors and IIT, they worked and sit many meetings with the IP professionals, and we worked together, and the grant of the patent was done by Indian Patent Office as well as US Patent Office. This product is in the market now, and it is already licensed. So I just want to say the doctors are very important. Whenever we have, because IP professional cannot have all the capabilities, they cannot have all the expertise of the medical field, engineering field, and IP field. All they cannot have, but support is required from the inventors. So it was always given. Or even in hearings, when we go for hearing in patent office, these doctors from Maulana Azad, IIT inventors, they always, engineers, they came with us, and we together fight, and then application was granted in both the countries. So this is just, I want to show you the how patent documented first page of the US patent of this dental implant. Everything is here. All the information is there, the inventor's name, assignee, and all. If you read any of the patent document, you will find similar kind of this information. Whole lot of information. Full document is available. So please read before you file any application. The relevant prior art, the status of the prior art, everything is there. This is again another application, or the patent granted to CSIR, the chemical case, drug molecule, and you will get a lot of information. And now I just want to tell you quickly, I think time may not be permitting much, but parts, what is the patent document actually to be submitted to patent office? There are some forms are to be submitted along with the technical information and the legal information. So what is the legal information? Legal information is simple: name, address, contact details of inventors, assignees, assignments. This is called Form 1. This is to be filled correctly. If you make any mistake in this, then it will be difficult to correct it. So a lot of problem may be there. So this is Form 1 is called as application form. And then technical information is in the form 2. That is, these we call it as a specification, which describes the invention. This is very important. When you write an invention, what is to be written or what is not to be written in this form 2. Form 2 is very important, and I think it is a specialized work. When you write an invention, you just go through the professional person, you write, give the information, and then provide it in a structured document. And there are some other forms are of form 3, form 18(9), where when you come to file the application, you will get to know the power of authority, request for examination. All these are to file along with the fee. Fee is also very, very important. If you don't file the document with the fee, it will not be entertained by the patent office. I was talking about the form 2. This is a techno-legal document. Actually, this is a business document. Then the patent will be granted. In this form 2, content will be very, very important. Why? Because the business person will see what is the scope of the invention, which is described here in form 2. It is a structured document. So all these are the headings. Actually, I'm just I've given the headings of the content, what it contains, title of the invention, abstract. Even title should be very, very precise, and how to do that is an art. Actually, how to do it. Abstract, field of the invention, background, summary, and everything, objects, detailed description, advantages, and sequences. Sequences are very, very important in case of the biotech inventions. If you have a biotech invention, definitely you will be having some sequences, and the drawings you have to submit. Sequences should be in an electronic form. They should be there in a proper format. And claims. Claims are the most important things which define the scope of the invention. If you have disclosed it in the form 2, these headings, you have disclosed many things, but you have not claimed in the claims, you will lose that product. Actually, you will lose the scope of the invention. So claims are the heart of the document. When you write a claim, it should be very carefully seen what to write, what not to write. So I just proceed with what are the procedure actually. When you are having the document form 2, form 1, everything ready, submit it. Filing of patent applications means you have to submit it, as I told you, any of the means, and the best way is to file electronically to the patent office portal. Go to and submit the document. All forms are there. You submit it, fill up those forms and submit it, and fee is to be paid. And you will get the fee. You will get the receipt out of it, and that will be the date when you are filing. That will be date of filing of the application. And then step 2 will be the filing of request for examination. If you don't file the request for examination, then patent office will not examine it. But if this request for examination may be filed at the time of filing the application or later. It is 48 months from the date of filing. So that means step 1, step 2, the between time is 48 months. If you don't file request for examination, it will be abandoned. Application will be abandoned. Nobody will take care of this, and it will be just status will be abandoned on the website. So the time limits are very, very important in the process of filing the application. Then application will be from date of filing of the application within 18 months or after 18 months from the date of filing, the application will be published on the portal, the Indian website, Indian Patent Office, or any other website, any USPTO, they will publish. 18 months is the deadline actually. 18 months, within 18 months, after 18 months, it will be published by a patent office. Suppose you are filing in US, it will be published in USPTO website, or in India, it will be Indian website, or Japan, or any country. They will publish it. This is the mandatory requirement for publication. Then it will be examination. If you have requested patent office to examine it, they will examine within that time only. If you forget to file the request for it, it will be abandoned. Then examination will start. Step 4 will be the examination of the application. They will be examined by the patent office examiner and controller, and they will give you the report on it. lot of questions and all these will be asked by these people. You have to revert it. Examination process itself is a time bound, and you have to give response to the patent office. And then if everything goes well, then it will be left for pre-grant opposition. Period is 6 months, at least 6 months. And if anybody is interested, they can file a pre-grant opposition. And then if there is no opposition, then application will be granted. Grant of application will be there, then it will be left for 1 year, this post-grant opposition period. So if it is also over, then if there is no opposition, then application will be there, and then it will be, you will get the, even for grant of application, you will get immediately the certificate for the grant. So all these steps are very much time bound. You have to work on the deadlines always. If you miss any of these deadlines, application will be abandoned. It is simple like that. And this is whole procedure actually, patent application, kinds of application, provisional. Suppose you are in hurry, you want to file the application, you have to present somewhere, you can file the application provisional. Provisional application is very simple. You just file the application along with the fee and minimum fee, whatever it is, depending on the entity, actually, larger entity or small entity or individual or startup or anything. So you have to file the provisional application. Then you have given the 12 months time from the date of filing the application. Provisional application, you have to complete it. If you don't complete, you don't file the complete specification, then it will be abandoned. So keep in mind to file the application within the stipulated time. Then after that, it will be publication. And as I told you, request for examination is filed. Then this is all the procedure is depicted here in the grant. Now I just want to point out here, the government has done a lot of work to facilitate the filings, particularly from the educational institutions, universities, and small entities, startups, natural person. They want to increase the filings. So what they have done, they have reduced the filing fee. And for other major entities, it is as such. So for suppose in CSIR, if an application is filed, then 8,000 rupees is a minimum patent application fee. Within 10 claims, and the number of fee depends on the number of claims actually. Number of claims and the number of pages. So number of claims will be 10 on 30 pages maximum. So the fee fixed is 8,000 rupees for CSIR or any major entity. It is 8,000. But for natural person or startup, small entities, it is educational institution. It is 1,600 rupees only as a filing fee. And for each page, if you add on after 30 pages, it will be 10 rupees, 800 rupees for major entity and 160 rupees for these natural person and startup. Similarly here, for each claim, if a major entity increase the claim, even a single claim, major entities for it is 1,600 per claim, additional fees there. And similarly here, for natural person or startup, a small thing, then 430 rupees each claim. And request for examination, you see the difference is 4,000 rupees in this column, and here for major entities is 20,000. So for each step they have reduced. This is, I'm simple here showing the patent application filing fee, then examination fee. Many fees are there. If you see the Patents Act, it is already elaborated. I'm just showing here as an example. So you can have this idea. They have reduced the fee to increase the filings from Indian residents. Because in India, we are having the patent application from outside India. People are filing, but Indians we are not filing much applications. So this is the reason natural persons, educational institutions, they should also file because of the cost reduced by Indian government. Now, after the grant of the application, we have to pay the maintenance fee. Means we have to, after the onset of third year from the from the date of filing actually. So for 18 months, two years are free, and for 18 years, we have to pay the fee. If you want to keep the patent life up to 20 years, for 18 years, we have to pay the fee. If it goes to 20 years, then the fee for the small entities, natural person, educational institution is here depicted in this table. First 4 years, it is 8,000 for, and then it increases. Similarly here, for major entities, it is 4,000 rupees per year for first 4 years. Then next 4 years, 12,000 rupees. For the next 5 years, then 24,000. And for last 5 years, it will be 40,000 per year. If you compare the fee, the small entities and the major entities, huge difference is there. So this is again the reduction in the fee for the maintenance. Government has done it. So I must say thank you very much for the patience. I think I maybe I might have taken more time. So I just leave for now for discussion. If you have any question, please tell me, or we can have a discussion now.
Yeah. Thank you very much, Dr. Indra Dwivedi, for enlightening us on this patent filing in Indian scenario, and what is patentable and what is not patentable, and various procedures and product patent and process patent, whether it's a licensing or enforcement rights. Since already it is over 2, I think many are hungry, and I'll just quickly go through some of the questions raised by some of the participants. One of the questions is that if the indication of a drug is different for which it is invented, then can we patent it?
Can you repeat the question? I'm not able to hear you properly.
If the indication of drug is different for which it is invented, then can we patent it?
I'm not able to hear. Just can you repeat? The few words are missing actually. If you.
The question is, if the indication of a drug is different for which it is invented, then can we patent
yes,
it?
that means indication means new use of a known substance. New use of a known substance. That means, as you are saying, I'm sure you are asking this question, if you have a drug and this is known and used for some other purpose, is it patentable or not? Is it right?
Yes.
You can have a formulation, but it should be synergistic formulation. It should be some having more components or something, better treatment or different treatment. It will be a patentable subject matter.
Okay.
Because if you have a patent, if you have a compound X used for already known for US, suppose, and it is known for treatment of cancer, and if you find it is useful for any neurological disorder, it will be a subject matter for patent in other countries. But in India, to make it patentable, you make the formulation claim. It will be a patentable subject matter.
Okay. One more question is that if we prepare the product with a simple method with a different material, is it patentable?
Yes, definitely it will be a patentable. Different material, you are starting with the different and making the cost-effective method, definitely you will be making the economic significance. So it is a patentable subject matter.
Okay. There is one more question. Can we patent the property of a plant extract that has been presented in a national conference and the abstract has been published in the proceedings?
If it is already known, it is published, and then it will not be, first thing is novelty is lost. So one of the criteria, most important criteria is already missing. So it may not be patentable. It is already published.
Already it is discussed in the proceedings of the conference.
Proceedings, if it is publicly available. If it is publicly available, then it will not be patentable because it is publicly available. I just want to mention one thing more. Can I spend 1 minute?
Yeah.
I just want to say, whenever you are having thesis or any conference proceedings, you please check it should be through the IP cell. It should be screened by the IP cell. It should not go without screening. This is my advice actually. So it will not happen. Or if a student is submitting the thesis, it is made public on the portal on the internet. If there is a content in that thesis or in the paper, it will come in the public domain. It will hinder the paper.
Okay, there is one more last question. With this, we will just conclude the session of the day. And the question is like, which method do we prefer to file a patent, as a natural person or through attorney?
As a method patent and?
As a natural person or an individual or through attorney?
Actually, best thing is, if you are expert in writing the patent application, and if you are aware of the law, how to write, how to submit, how to file, how to prosecute, then that way you are saving money, because attorney you have to pay for this. They charge a lot of money for the drafting the application and filing the applications. You can, if you have capabilities of doing this, you can file it yourself, no problem. But if you don't know, then it is advised to file through the professional, IP professional or attorneys.
Okay.
मीटिंग आहे बाय दुपारचं भर काय कशी मीटिंग चालल्यावर
Hello. Yeah. Thank you very much, ma'am, for your elaborative and very comprehensive deliberations on the patent filing in Indian scenario, including very good examples in the biological and clinical sciences, as well as the patenting fees in Indian scenario. So with this, we just conclude today's session. And Dr. Amin would like to say something.
Yeah. Thank you, Dr. Indra Dwivedi, for an excellent talk. And I think we'll get back to you with a few more questions in case if it's possible. And since we have got your email ID, we will try to contact you. And generally in our research talk, we always say that being is cannot be reinvented, but it can be made to go fast, or you can try to make different designs of it. So that is patentable. So here also, in case of cancer research, we know that there are certain monoclonal antibodies which can be patented. And there are some techniques which the students will always have, new techniques and shortcut methods or time-saving methods, which can help a student entity to provide patents or just apply for patents. So this will increase the number of patents in our cancer research in this particular profiles, which can be added. So what is your advice, the final advice?
Actually, my advice is you can start thinking your IP first. Try to collect that IP and start proceeding for filing. Actually, this is the thing. You can start within the system itself. You can have the 1 or 2 persons just to start with the filing of the filing. You may not be doing yourself, but you can file the application through attorneys. You can impanel it and then file the applications. But at least you should think about this and make the IP cell in the department and in the organization, and then screen all the publications before they go for publication. Before they publish it, screen it. They should be screened by the this IP cell, and then they should be allowed for publication. So the content which is patentable, it should not go out from the hands actually. And the students, they submit the thesis, it should be screened by the IP cell, and even before publication and taking the project, even they should know what is patentable. They should not disclose it to any of the, and they should not do disclosures outside the organization or outside the group. Keep the dates available with them, when it was conceived, who are the inventors. All these records should be there. as we do in IRIS actually. This is the same kind of things we should have here. The dates are very, very important. Everything should be recorded and students should do it. And then because we don't know when these dates are to be submitted to any place. So these are very, very important things we should have. And analyze the prior art, do the prior art search first, analyze what is the content, whether it is patentable or not. If it is patentable in India, first file the application in India. Not much money and efforts are needed in India. And if it is very important, within 12 months from the time of the date of filing the application, it may be filed in other countries. If you feel it is very important technology or very important molecule having excited results, you can file in other countries if you think. And 12 months time enough is given in a law, actually Paris Convention. So you have the priority date from the Indian filing. And I think this is very important at this point of time to capture the IP generated among the students and medical doctors here. And they should also realize it to help you in this IP culture. They should enhance the IP culture in the country. This is my advice.
Okay, thank you so much, ma'am. Over to Satish.
Thank you very much, ma'am. With this, we conclude the today's session. And thank you for joining us from various locations, including Varanasi. We heard that a good number of participants joined from Varanasi auditorium as well as our TMH auditorium. So thank you one and all, and have a nice day and have a nice weekend. Thank you. Thanks, sir.
Thank you so much for inviting me. Thank you.